Thank you very much for watching this. This is going to be a short presentation and it arises from, it's recording this on the 23rd of June, and it arises from questions that we're getting from clients and others in relation to the return to work, distressed businesses and how to deal with issues arising, and actually some clients who are buying assets out of distress or from insolvency practitioners. So we just thought it was a good time to have a quick overview of some of the questions coming up and the issues arising. My name is Barry Caher and I'm the Head of Insolvency and Restructuring at Beecham's. I'm joined today by Damien Maloney, a partner in our corporate department with experience in distressed assets and distressed investing, and Sandra Masterson-Power, who's our Head of Employment and dealing with all sorts of issues arising from the current situation relating to COVID-19, ceasing work, return to work, and everything in between. So I'm going to start off really on the trading and risks for directors, and the question we're getting now that businesses are reopening again and again, we're asked about personal liability for directors. It's obviously a concern when trading through a corporate entity. And the answer to that is quite simple, is that directors really can't be held personally liable for the debts of a company or the liabilities of the company unless they've been trading in a fraudulent or reckless manner. And that rarely arises in real life, and certainly fraud is quite rare, and recklessness is something that's defined by a complete disregard for the interests of others impacted by your decisions. And in a difficult or distressed trading environment, that means the creditors. So if directors behave in complete disregard of the creditor's interests, that can be reckless trading, which can give rise to personal liability. The other question that arises that people are aware of from media coverage and otherwise is the potential for directors to be restricted or disqualified from acting as directors in the future. Now, that only arises where the company goes into liquidation and a liquidator has to make a report to the Director of Corporate Enforcement. And the defence to a restriction or disqualification allegation is that the directors have at all times acted honestly and responsibly in relation to the affairs of the company. And so again, it should be clear that directors who are behaving in the best interests of their stakeholders, earnestly trying to plot a way through the difficulties, should not trigger any allegations that they have acted other than honestly and responsibly, and should not therefore face restriction and disqualification. What's been very helpful in the last couple of days is that the Director of Corporate Enforcement has issued some guidance on these issues. And while the Director has not restated the law, it has given some clear signposts as to how it will approach these issues in the period to follow. And the summary, if you like, of that guidance is that the Director of Corporate Enforcement will not regard directors as being responsible for events that are completely outside of their control. Now, it doesn't mention COVID-19, but given the timing of the guidance and the context, there's a clear signal there. The guidance also refers to recent case law on these issues and notes that the Director of Corporate Enforcement will take account of these cases. So what are the behaviours that can protect directors in these situations, and what have been referenced by the Director of Corporate Enforcement are as follows. The adequacy of the monitoring of the business. So if you're trading in a distressed environment, you need to be able to monitor the progress up and down, and that monitoring has to be of an adequate quality in order to defend your decision-making processes. The director also references the taking of professional advice, and case law supports this as well, that it's important that directors take appropriate professional advice. That could be accounting or legal or tax or whatever the specific issue might be. And to summarize really those behaviours, it means that there has to be objectively verifiable evidence of the decision making and that it's good decision making. It doesn't mean that you have to prove a financial or economic success. It just means that you have to be able to show that you made decisions on a rational basis and were therefore justifiable, honest and responsible behaviour for the purpose of trading through distress. So the takeaway, I think, is very important, is that it is possible, the law supports it, the Director of Corporate Enforcement supports it, it is possible to trade through these issues, and it's not always necessary to close the shutters or pull the plug. If the distress is such that you can see a way through, but there are certain liabilities that are difficult to manage, there are a number of formal processes available, and I'll touch on these very briefly. The first, and perhaps the most talked about in recent times, is examinership. Examinership is a process that gives the company protection from its creditors for a period of 70 to 100 days, while the directors remain in control of the company, and the examiner, who's independent of the company, tries to put together, find investment, source investment, and put together a scheme of arrangement whereby the company and its business can be put in a position where it survives as a going concern. Again, it's very important to be aware of the fact that it can be an expensive process, but it's also available for smaller companies through the circuit court. A small company in that context means that you have a turnover of less than 8.8 million, a balance sheet value of less than 4.4 million, or an average number of employees less than 50. So it is accessible to a lot more companies than I think people had previously thought. It is also possible to enter into a scheme of arrangement with creditors without entering into examinership. In recent times, this has been used a lot by international companies to scheme bond and other financial debt. So trade creditors, for example, mightn't necessarily be schemed. It is a useful tool, but the bar can be pretty high, where you need a majority in number representing 3/4 of the value of each class of creditors in order to enter into a scheme. It's done largely out of court. The court does sanction the scheme at the end of the process. But it's certainly something worth looking at if there are certain liabilities capable of being restructured in that fashion, and it's not necessary to restructure all of the liabilities of the company. The other thing that's outside of a formal process to mention here is an informal arrangement. Now, there are a couple of principles that are necessary in order to successfully achieve an informal arrangement, and that involves creditors more or less agreeing to a standstill for a period of time. The information that the company shares with the creditors must be consistent so that creditors are stabilized. It's generally unwise to share some information with creditors and not share it with them all, or at least all of those affected. It can be very useful to encourage the creditors to coordinate their representation so that there's one point of contact for the creditors as a group in relation to trying to come to an arrangement. And the principles that apply if you're going to persuade your creditors to enter into a scheme or to some sort of an informal scheme is you have to be able to show them that they'll do better if they accept the proposal than they would do if the company went into liquidation. That's the guiding principle. While difficult, I think that the current environment lends itself particularly well to informal schemes, because all of your creditors are in a similar position at the same time. It's a very unusual situation where you would have all creditors undergoing the same distress all at the same time. Because even in the last recession, the bank liabilities were under most distress initially. And so it depended on whether or not you had bank or secured liabilities as to whether or not you were experiencing the same levels of distress. But at the moment, landlords, tenants, occupants, customers, suppliers, everybody's in the same position at the same time. And therefore, the possibility of an informal and out-of-court arrangement with creditors seems to be much more viable than or achievable than it might have been in the past.
Thanks, Barry. Yeah, it's certainly a different environment to what would be the norm in our M&A practice. I mean, typically in an ordinary economic landscape, we would see 80% of our transactions, 80% by volume, being done by way of share sale. Whereas at the moment, we'd expect to see an increase in business and asset sales. And there's a couple of reasons for this. I suppose, the purchaser in these situations is in a stronger negotiating position typically. The deals are often being looked to be done in a short turnaround time. So that gives the buyer limited timeline to conduct any sort of robust due diligence. What that leads to essentially is the buyers looking to say, well, we want to cherry pick the assets then, where we don't want to take the shares because that gives us the whole box, warts and all. So we want to cherry pick out the assets so we can leave the liabilities behind. We haven't had time to run the rule over the business in totality, and therefore they get carved out by way of business and asset sales. A hybrid of that, I suppose, is where you do a sort of a hive-out situation, and that can end up being a best of both worlds scenario, maybe for a seller and a buyer. This is where the seller would firstly put those assets that the buyer has identified into a new co, and then there would be a share sale of that new company, which would just have within it the assets that the buyer has identified. So again, from a buyer's perspective, gets to leave the liabilities of the legacy company behind, gets just the assets they want, but gets them by way of a share acquisition. And I suppose from the seller's perspective, it maybe gives them the opportunity to realize a better price for those assets. Because again, in the previous situation where there's that limited due diligence and so on, there's always the pressure from the buyer to reduce the price to compensate it for the risks it's taking. M&A will still happen in the ordinary course, I guess, in the sense of share sales, and except I would term it accelerated M&A in these scenarios, because again, while you're still looking at doing an accelerated M&A, ultimately is still a share deal. It comes with the issues of the reduced time for due diligence, and the knock-on effect for the seller then in those situations tends to be having to take a haircut on price. I suppose the types of things you'll maybe see sellers do in those situations to try and drive the best prices, to run a kind of an auction process to try and bring in the best deal for itself. And the buyers who tend to participate in those types of scenarios would be the types of buyers who are well used to those scenarios, well used to taking risks, have the appetite for it and the track record, and get advisors on board with them that they trust to distill the pertinent risks for them. Minority investments, I suppose, is going to be a feature as well. They're always on the landscape anyway, but this allows a buyer to come in at a certain level. It gives you a balance between the seller retaining some value and the buyer managing its valuation risk. And again, there could be mechanisms tied to a minority investment which would allow a buyer to increase its investment, maybe, and ultimately maybe grow to 100% over time. And then, as I've touched on, big issues here all along are the valuation issues and the due diligence challenges, and those we would expect to see driving out of those then in our deal documents, solutions like earn-out provisions, where the purchase price is paid out over a period of time, depending on certain hurdles or milestones being achieved, or escrow provisions. So similarly, part of the purchase price being locked away. At least buyers would be seeking to push for that. Clearly, escrow provisions don't favour sellers who are, as I said, looking to realise value as quickly as possible.
Okay, thanks. And so that's kind of the structural issues and the kind of deal structure you're saying. And what are the actual transaction issues then you're coming across, Damien?
Yeah, so some of those I've touched on. I've thrown a few of them together here. I mean, due diligence, to go back to again, due diligence, it's just a feature of these transactions in this landscape, in this environment, in a distressed business. There's a pressure on to get the deal done. And therefore that gives the buyer limited time. Buyers in these circumstances may have limited resources, to actually throw bodies at the due diligence. And maybe less of a concern at this point in time, given where we are in the lifting of phases and so on, but access constraints to physical due diligence, to get in and get access to physical documents where that would be necessary as part of the due diligence process. That certainly over recent months, maybe more so of an issue than it's going to be in the months to come. And I suppose where, there's two things here for a buyer to think about. One is experienced advisors, getting people around you, people on board who can help to quickly distill the issues and prioritize the most material risks. And secondly, legal technology. Legal technology on the due diligence front has come a long way. There's some fantastic packages out there now based on artificial intelligence and machine learning, whereby you can dump a big due diligence bundle into them, and they can act, using some keyword prompts and so on. They can act to distill the issues for you and highlight where the red flags are, for your advisors to then drill into. Warranties and indemnities. Again, typically the issues you're looking at there is that, well, number one, a seller may not be able to offer any, and number two, a seller may not be in a position to stand over any warranties and indemnities that they might even offer, because, as I say, they may not have financial wherewithal to be a mark for warranty and indemnity claims going forward. Historically, warranties, indemnities, insurance wasn't available without a robust due diligence process, but we're certainly seeing that more and more providers now willing to provide warranty and indemnity insurance in a distressed market. For example, selling a kind of a pre-pack of warranties based on a certain level of due diligence, perhaps not your full robust due diligence that you would see in an ordinary course, but if you get to a certain threshold, you'll get an insurance pack.
And of course, if you're buying from a liquidator, you're unlikely to get any additional warranties or indemnities.
That's fair. Yeah, that's fair comment. I mean, I'll talk in a bit about the timing of when you might do a sale, or the pros and cons of buying pre the process, the formal process, versus in the formal process. But you're absolutely right. Of course, liquidators and insolvency practitioners, officers in general, you buy as is in a situation like that typically. Third-party consents is a feature and something to be borne in mind, particularly in the business and asset sale world. If you are looking to structure your deal in that form, can actually make those forms of deals, while I mentioned earlier, they may be more preferable to the buyer. They can actually be more complex because of having to go to a third party to get consent for a sale to happen, for an asset to transfer. And I suppose finally, just to throw it in there, it's a feature anyway in all landscapes, be they distressed or ordinary economic environments. But merger control will remain a feature. So again, if your deal hits the merger thresholds of an aggregate 60 million turnover of the joint entities, or two or more entities having minimum 10 million turnover each, then what may happen is you end up with a gap between signing and closing, because you get the deal done in all its commercial factors, you get your transfer agreement signed, but there's a gap between signing and closing while you wait for the merger clearance to come through. And I suppose what we'd expect there is there to be some very robust clauses around the the rights of the buyer in that gap period, walkaway rights, if you know, again, in the case of material adverse change in the environment. And some interesting, you know, typically in that kind of gap between signing and closing, you would have clauses in there that would oblige the seller to conduct business in the usual course, or in the consistent with the way it has been previously run, past practice. But of course, you know, the COVID world and the COVID operating world, you know, what is the ordinary course of business, and what is past practice over the last number of months, particularly, versus what future practice might look like. So the interpretation of those clauses in a situation where you have a gap between signing and closing would be quite interesting.
Plus, you don't always have the luxury of those timelines. I mean, can you tell us a little bit about the factors that influence the timelines in these transactions?
Yeah, I mean, you touched on some of it earlier there yourself, particularly around making the decision. Well, you mentioned the deal in a solvency, in an insolvency process, or if the company is outside the insolvency process, and the different timing factors that might apply. I mean, if you're buying outside of the solvency process, there's benefits there potentially to the parties. They may want to avoid the stigma for the company of actually ending up in an insolvency situation, and the potential impact on goodwill and so on that might bring. But you know, as against that, then you have the risk from the buyer's perspective that if it buys outside of an insolvency proceeding and it buys at what is perceived to be a very suppressed price, then the potential of the transaction to be open to creditor challenge down the line is always there. And you know, there's the risk that if a creditor was to successfully challenge, then the transaction could even be unwound. I suppose a hybrid of this would be a situation where you look at doing something like a pre-pack deal, where your transaction, your sale of assets are negotiated outside of the insolvency proceedings, all the way right to getting an agreement on your commercials and your documents and the whole lot. And then the company enters into the insolvency proceedings with the deal already there to fly. And so the idea would be that the period in insolvency or in the proceedings would be very minimal. It would minimize disruption to trading. Now, your insolvency officer in those circumstances, of course, still needs to be happy that the price that was negotiated outside of the proceedings covers, that he's comfortable that it is the best possible price for the assets or the business, because again, that's key amongst their duties and obligations. But you know, there can be some speed and flexibility to having done the negotiations in advance, and then getting, from a buyer perspective, essentially having the court blessing on the transaction, and if you like, giving it some protection against those future challenges, future creditor challenges. And then finally, you know, you have the fully insolvent transaction, if you like. So the company has gone into its insolvency proceedings, and then again, there are benefits, of course, for the buyer here. They can buy the assets of the business without liabilities. It gets the court approval, as we mentioned. There's a stay, could be a stay on creditor proceedings. But those old issues from a buyer perspective that I mentioned earlier, there'll be little or no due diligence. And as you rightly mentioned, Barry, there'll be probably no warranties or indemnities. So the buyer is fully on risk. And, you know, price is probably the best thing they can hope for there, to try and batter down the price as best they can because of the risk that they're taking on in those situations.
Okay. Well, thanks very much, Damien. I mean, Sandra, if we might have a quick chat. I mean, we could talk all day about the kind of things that have come up, novel issues coming up, whether it's the wage support scheme and all the issues related to that. But just leading on from transactions and distressed transactions, people understand generally, I think, that if you acquire a business, you acquire the workforce as part of that business. But how does that work in the context of a distressed acquisition?
Yeah, okay, thanks, Barry. Well, as you say, TUPE, or the European Communities Protection of Employees on Transfer of Undertakings Regulations 2003, which is a very long title. That's why we use the acronym TUPE. generally applies where a business or undertaking is transferred. And so under those regulations, as people will be familiar with, employees transfer over to the new business. In terms of distressed businesses, the regulations don't actually deal with the sale of a distressed business, other than saying that 2P doesn't apply to liquidations or bankruptcy. So it's very clear. However, even though the regulations specifically exclude liquidations and bankruptcy, I am aware in practice of instances where the distressed business with a court-appointed liquidator was then sold as a going concern, with the employees transferring over under 2P. And I suppose it makes sense in many ways, because the whole purpose of 2P is the protection of employees. But those cases can perhaps be distinguished because it wasn't a terminal insolvency. And there are some European Court of Justice judgments supporting that approach, say that if the undertaking continues to trade, even though it's been wound up by the court, which had happened in those cases I've mentioned, the continuity of the business is assured, then this makes sense. There's no justification for not allowing 2P to apply, as to do otherwise would actually deprive the employees of the very rights that they're given under 2P and under the directive that governs it, which the rights that the directive is seeking to protect. So, but this question has actually never been decided in the Irish courts that I'm aware of. I can't find any decided cases on it. So I suppose it's important that legal advice in relation to the applicability of 2P in the sale of a distressed business is sought, particularly in a liquidation context, because, as I say, it's not entirely clear cut.
Okay. And in situations where you don't have a transaction or a divestment of a business, and we're now almost 2 weeks into sort of certain small retailers as defined reopening, we're about to go into phase 3. Can you tell us, because it comes up again and again, where employers have laid off staff, do they need to take them off, layoff, as it were, as they reopen, or what's happening in that?
Yeah, so this is I suppose, a perennial problem, and I suppose with layoff, it's really going to depend on the needs of the business in question. Layoff is in fact a temporary solution. So it arises where at this moment in time, there is no work available for the employee, and the employer reasonably believes that the, quotes as in the legislation, it says the cessation of work is not permanent. So the employee remains an employee during layoff. And I suppose what's curious is that the legislation doesn't actually set a time limit, but there is a mechanism by which the layoff can end, and so that the employee could trigger the ending of the layoff. And in normal circumstances, what would happen is an employee triggers the ending of the layoff by serving a notice of intention to claim a redundancy payment on the employer if he or she has been on layoff for 4 weeks in any 4 consecutive weeks in any 13-week period. However, when we entered into this crisis, the government anticipated that there would be a tsunami of claims of employees seeking that statutory lump sum redundancy payment, where many of them, lots of employees, had been placed on layoff. And that would have put organisations, businesses, under even more financial pressure if they had to pay out redundancy payments. And so with emergency legislation, and people are familiar with it now at this stage, they suspended the statutory right of the employee to serve the notice of intention to claim the redundancy payment. So it was initially suspended until the 31st of May, but that has now been extended until the 10th of August. So I suppose that gives organisations, businesses some breathing space if they are contemplating redundancies, or if perhaps their bank balance, the cash reserves aren't there to pay out the redundancy payments. So as long as that right to trigger by the employees is suspended, they don't have that additional financial pressure of paying out statutory redundancy. But of course they can do if they so wish, if the reserves are there. Now, it's possible that that right to trigger may be extended for a further period after August. It's difficult to know. I suppose it's really going to depend on whether the economy bounces and how many employees are brought back from layoff, or what businesses do. But certainly as businesses start to reopen and trade again, they're obviously going to be looking at their workforce and doing workforce planning and who they're going to perhaps bring back off layoff, and whether some or all of these employees can be brought back off layoff and reintegrated back into the business, or unfortunately whether some of them are facing redundancy either now because simply the business plan doesn't sustain the number of employees that they previously had, or possibly after reopening if trade doesn't pick up.
And in a way, it's tough choices either way, but where you are returning to work, the business is viable, but there's a reduction in workforce required. How do you select and how do you deal with the costs of redundancy in that situation?
Yeah, so that's a difficult, redundancy is complex and it's difficult for businesses. I suppose the fundamental thing is the employer must act reasonably. And in terms of selecting who to make redundant, the selection process should be fair, transparent, objective. And I suppose by its nature, it involves, the selection process requires some level of discussion or consultation with the employees. And certainly that's something that we've seen time and time again before the WRC, where the redundancy is an unfair, which is a dismissal, has been deemed fair, but the consultation with the employees has been deemed not sufficient. And so that's where payouts for compensation have been made to employees. But unhelpfully, I suppose, in terms of dealing with selection criteria, neither the redundancy legislation nor the unfair dismissals legislation actually set out criteria that might be applied by employers when they're considering selecting employees for redundancy. So it falls to each employer to set out what the criteria that will be applied to the employees. And I suppose it's important to remember that those criteria will come under very close scrutiny before the WRC in the event that an employee claims unfair selection for redundancy. So it's really important, it's crucial that employers can objectively justify the criteria chosen and how it was applied. And traditionally, back in the day when I started practicing as an employment lawyer, last in, first out was the tried and trusted method. There are some issues with that now in terms of possible discrimination. If you're a young person and it's your first job and you're the last person in, well, then you're going to be the first person out. So there are some issues with that. So it has to be looked at carefully. A selection matrix, that's probably the most common now, where employees are scored against key skills and other work-related matters. So it's going to depend on the particular business. And some do an interview process. That is quite cumbersome, I think, but it's going to depend on each organisation. But they're all methods of selection that can be used. In terms of, and I mentioned consultation, that's very, very, really important. We're looking at either individual consultations or redundancies, or if it's large-scale redundancies that meet the threshold for collective redundancies, well, then the consultation processes are mandatory, as is the notification to the Minister for Enterprise and Social Protection. So whichever way, whether it's individual, small numbers, or whether we're into the collective redundancies, the consultation process is key and is really the foundation for defending a claim for unfair dismissal. You asked there in terms of the cost. Well, employees that have 2 years service, or 104 weeks as it is in the legislation that have the social welfare stamps, they're entitled to 2 weeks pay per year of service, and that's capped at €600 per week. So it's 2 weeks pay per year of service, capped at 600 plus a bonus week, together with whatever statutory or contractual notice periods and all outstanding holiday pay. So it's quite, the employees have long service. It could rack up to quite an expensive operation. What I will say though is employers who can't afford to make the statutory lump sum redundancy payment may be eligible, and I'm saying may because they will obviously need to do their own due diligence, if you like, and inquiries in relation to that, but they may be eligible for the redundancy payment scheme, which is operated by the Department of Enterprise and Social Protection. So that may offer some relief if employers are in a position where they need to make employees redundant, but they simply don't have the cash to fork out the redundancy payments. That they can certainly look at the redundancy payment scheme.
Okay, Sandra, thank you very much. I'm conscious of time, so what I'm going to suggest is that we will put our contact details up on the slide. Sandra Maston-Power, Damien Maloney, and from me, Barry Carter. Thank you very much. Please don't hesitate to contact us with any queries and details to follow.